And applause to Tom. Yes, thank you. Make sure we catch that on camera. I've got some handouts here. Let me, which just take one, pass it down. I think they're just, and you'll end up with extras. I have even more handouts here. Take one, pass it down. Today I was, or several weeks ago, I was asked to talk about the relationship of an attorney with a business, and when would you use an attorney, and in particular, before you start, when you open your business, before you start opening your business, what sort of entity would you choose? What's that going to look like legally? Now, how many of you are familiar with corporations? Okay, everybody's heard of corporations like Microsoft. How about a limited liability company? Okay, 1, 2, 3. Okay, how about a corporation sole? No, corporation sole. Don't worry, none of you are probably going to be involved with that. It deals with religious types of corporations, but it's...
Look at us as...
Huh?
We're not very religious.
No, this is not... Well, they're not that common. This is not going to be a faith-based discussion, but I didn't suspect that that would necessarily fit anybody's. I didn't try to evaluate you as to whether you would be appropriate for the use of that. But I wanted to start out with a choice of entity. How do you choose what you're going to look like when you form your business? And the reason I want to talk about that is because they've got tax implications, organizational implications, interpersonal relationships. It's like, what's your marriage going to look like? Are you going to marry, are you going to stay single the rest of your life? Are you going to marry one person? Or actually, in a corporate sense, corporations are polygamy. I won't go there, but basically a lot of people working together to make this business run. First type of organization, sole proprietorship. Entrepreneurs are usually seen as sole proprietorships. Yes, they've got this great idea. I'm going to go out and do this. Now, sole proprietorship means that you get your own business license. When somebody looks at the business, they're looking at you. And you are the business and the business is you. It's all kind of mixed in the same pot. Tax implications, your tax return, it all looks the same. You've got a Schedule C on your tax return to report your income for business activities, but it's your tax return. And so if anything happens to the business, if there's a claim against the business, it's a claim against you personally and can reach you personally. Let's say you're running a delivery business and you run into somebody and it's your fault. Well, you personally would be on the hook for, or liable for any damages that were caused that were your fault. A lot of different considerations as far as liability in that circumstance, but basically you are the company and the company is you. And this one handout that I gave you, the 4-page handout, this actually is a great resource. Found this online. The web address is at the bottom, and you can look at the entire document by going to that website. But this was a key summary for me as far as talking about the different entities, if you weren't already familiar with them. Sole proprietorship, if you're you can still have employees, so you'll need an employer identification number. Basically, it's the federal tax ID. And as far as liability, yes, the company is you, you are the company, you're treated as one individual, you're treated all as one, and indeed that's the same for tax purposes. Now you start inviting other people in, or you want some sort of limitation on your liability, your personal liability, then you would consider forming one of the other types of entities. Actually, formation of a sole proprietorship is pretty much applying for a business license and conducting business. There are still a lot of administrative steps that are going to be necessary there, but that's hanging out your own shingle, making your own shingle and hanging it out. Second one is a limited liability company or other forms of partnerships, and that's on the second page. That's where you would form an entity which is a separate legal existence, a separate legal person, that it's the business now, and you are no longer the business. You may run it. You may be the chief cook and bottle washer, but that business is a standalone entity capable of suing and being sued, capable of doing business in its own name. And a limited liability company, as a type of partnership under Washington law, affords individuals opportunities to protect their personal liability while still conducting business. If you're conducting business and keeping your affairs straight, not mixing your laundry bills with the business of the company, for example, not charging your dry cleaning to the corporate account, there are other ways that you can get messed up that way. But as long as you're keeping your accounts tidy, if you will, a limited liability company or other form of formally recognized partnership will be helpful in protecting you from personal liability, so they can't reach your house, your car, your bank account, your retirement, or any other assets that you personally have. Whoever would be making a claim against you would be making a claim against the assets of the limited liability company. Now, there is a concept of the alter ego where, I kind of treat the business accounts like they're my personal accounts. And yeah, I tell people I'm this business, but I'm really doing it. And if there's any question, then you expose yourself to being, having your corporate veil pierced, which is either based on the alter ego theory, the corporation is the person, is the corporation, which is they're so intertwined that you can't tell who's who. Or if you meet other criteria set forth in the statutes, like you make distributions to yourself before you make distributions to your creditors when those creditors are way overdue. They can pierce the corporate veil and go after your own individual assets if that's the case.
So another question, when you talk about the alter ego, if you're a sole entity, sole entity LLC, and you co-mingle, say for instance, I consult and I get a check from, like say the city for consulting with the city, but I don't have a business account where they deposit the money and it goes into my personal account. Can somebody sue me because there's a co-mingling of business and personal?
If you've established a limited liability company, for example, or another business entity, and you take a business payment and put that directly into your personal account, now you're exposing yourself to personal liability because you're now commingling. Now, the best way to handle a situation like that is for any business entity to have its own accounts, its own bank accounts, finances, own contractual relationships. For example, my law firm, I'm organized as a professional limited liability company, Anderson Law Firm, PLLC. And when I receive a payment for my services that I render through my firm, I have them make the check out to Anderson Law Firm, PLLC. I deposit it in my corporate account. And then if I want to receive that money, I take it as a draw. For corporations, it's referred to as a dividend. In the concept of a partnership or a limited liability company, it's considered a draw, a member draw. And so I would take that to account for that payment to me. So, and it's that sort of dividing wall between the acts of the business and the acts of your person that you need to be careful. Now, if you need to maintain that dividing wall. If you haven't done so, then somebody can say, well, he didn't regard that corporate veil, why should I? So there are a lot of accounting aspects here that you need to be mindful of to protect that corporate veil and protect the sanctity of the corporate form. There are other forms of partnership as well. There are also joint ventures, which are just generally looser agreements amongst people to conduct business, but it's not really a corporate form. A partnership, however, you can have a straight partnership, which is amongst several people, all of us, say, forming a partnership. In that partnership, you can have limited partners. Let's say one person comes in and say, I have a bunch of cash, I want to contribute to this, but I don't want any liability for any part of this. I don't want to run it, I just want to bring money in. And you could designate somebody as a limited partner, where they bring money into the entity, but sit there as a partner with limited liability within that partnership. The general partners, however, would have unlimited liability still for how the partnership conducts its business. Now, the limited liability company is a form of partnership created by statute that does afford you that limited liability, as the name. Now, so if you see an entity with partnership after it, or LLP or PLLP, which is a professional limited liability partnership, or an LLC or a PLLC, that's all. It's all a partnership formed under the laws of, I guess it's Title 25 of Washington State RCWs. Now let's talk about corporations. A real easy way to tell if an entity is incorporated is if it says company or Inc. in its name. And that's kind of an easy first check. Not-for-profit corporations are not allowed to have either one of those in their name, but if you're looking at a for-profit corporation, you'll typically find the word company or Inc. or incorporated in the name. You can take the form of simply a corporation, a professional services corporation, which can be abbreviated as PC. You see law firms with PC after the name. My last law firm had a PS after its name. They're all professional services corporation. A typical for-profit corporation, whether it's an S Corp, like it's discussed on this page, on the third page, or a C Corp, which is discussed on the final page, they'll typically have Inc. after the name, or incorporated. Each of those entities include, and also the limited liability company, they've got specific administrative requirements for their formation. And the Washington Secretary of State is your first stop for discovering what is necessary to be able to proceed with the formation of an entity. One of the more important aspects of this, and everybody's like, oh, it's like picking color for a bathroom, it's picking a name for your company. A lot of things go into it, like, okay, how do I attract customers? How do I tell people what my company's about? What's going to be attractive? What's going to be easy? What would make a good domain name? But one thing to think about as well, and you will discover this, is that name taken by anybody else? And one thing I discovered, I'm Anderson Law Firm PLLC. Well, in Tacoma here, there's another Anderson Law Group that is up the street. I get calls for, trying to reach that group when they reach me. So it's unfortunate I have to redirect them. Yes, the phone number is, let me know if I can help further. And you hate taking those calls. You think, oh, there's it's different, but not so different as to fully avoid the confusion that some people may have. Another thing I discovered, my domain name, my email address is marka@mba, my initials, esq.com. Well, not the easiest thing. You have to repeat it a couple of times, and I don't do well with the Q key when typing it out. So you may want to consider the integration of your name with your domain name as well, and how best to get that across. So that's about branding. That's not what I really wanted to talk about, but just kind of a side note. This next entity I want to talk about is an S Corp. Now these are corporations that are formed through the Secretary of State, Washington Secretary of State. And an S Corp is a specific form of corporation and the reason they say it's an S Corp is formed under subchapter S of the IRS Code, actually chapter 1 of the IRS Code, which is Title 26 of the US Code. And it allows specific tax treatment for smaller companies. If you have 100 or fewer shareholders in this, then you may make this election. There are other restrictions on this. You can only have one class of shares. You can't have preferred shares and then common shares, common stock. In the LLC context that we just talked about, an ownership interest is called a membership interest, often expressed as a term of percentage of the company. In a corporation, it's usually stock, shares of stock. And so in the S Corp, you can have no more than 100 shareholders. And an S Corp can be treated as a single member entity. I could have formed my company as an S Corp. I was going to have employees, in fact did. But for me, the tax advantage, there was no tax advantage. The only advantage to going with an LLC for me as opposed to an S Corp is because it costs less to do my taxes. That's about it. But when you're starting to manage more than one owner and you've got a corporate form, an S Corp can afford you specific tax treatment that you wouldn't otherwise get with an LLC.
What about protection? What's better, LLC or an S Corp?
It depends on your circumstance, whether you have employees and how many shareholders you've got, the size of your operations, and the best, a lot of these factors are described here on page 3, but the real impact is in the tax. And apart from an attorney, the next person I would recommend that a prospective business owner contact is a tax consultant or a CPA. Somebody to stick with you by your side as you go through the formation and operation of your business. Just some background, maybe in order here. I'm not a tax attorney. Most of my work involves commercial real estate, buying and selling real estate. I don't buy it and sell it, but I handle transactions. I also litigate on behalf of business clients and on behalf of some personal injury clients. So I have a broad base of knowledge, but it's like a jack of all trades and master of none. Well, I would only consider myself as being focused in a couple of different areas, but I know a lot of people who do everything else, which there's a lot of value in that I've found because it helps me learn. The last type of entity we talk about here is a C Corp, and that's formed under subchapter C of Chapter 1 of the IRS Code. And that type of corporation is, that's the Microsoft, General Electric, et cetera. They don't always have to be that big. But now you're talking about unlimited numbers of shares, typically, or limited only by your internal documents and by the Securities and Exchange Commission. You are taxed oftentimes at 2 different levels. One, on the corporate income, and then if dividends are paid out from the corporation, paid to the shareholders, such as you as an owner, it would be taxed to you as personal income. And so oftentimes for a very small business, a C Corp is not the way to go. But that's reserved for the larger companies. Now, in order to become an S Corp, you have to make an affirmative election with the IRS. If you just form yourself as a corporation, you're automatically assumed to be a C Corp. So be aware of that. If you want to form a corporation and you want it to be an S Corp, make sure you get your filing done on time. Now, the other half of what I was asked to talk about, and actually this is an important part, but it sounds like you have a question.
So,
please.
One of the benefits that I saw of being an LLC is that you can choose the way you want to be taxed. You can make an election of how you want to be taxed.
Yes.
You can make one election in a 5-year period.
Right.
If you don't elect anything, then you automatically are taxed as an LLC, which gives you the right, if later on, within a certain period, a few months, that if you want to change it because of the way your business is shaping, that you can make that election at that point and then be locked in for the 5-year period.
Right.
So that's the benefit I saw of the LLC.
Well, and the LLC that I formed it as a single member LLC. And with that election, that means it's all treated, for tax purposes, I am treated as the business. And so I file a Schedule C. All of my business income and outgo, my expenses, all of my business activity is filed with my return. If I didn't make that election, then I would have to file separate returns for the LLC itself, which can be problematic. If you've got more than one member in an LLC, then you're going to be filing separate tax return for the LLC itself with individual statements. I think it's K1 statements, Schedule K, whatever it is, for the individual members. But for me, I do all my taxes in one package. But I do have the capability of making that election later on. Let's say I brought on another member of the LLC, another law partner, then we could expand that then to have the LLC file its own tax returns. Any questions about, any other questions about what I've talked about? Okay. This was the most fun list to come up with. When would you ever use an attorney for your business? All right. How many of you think that attorneys are all like Perry Mason? Okay. Or anybody else. I mean, like Ally McBeal, whatever, LA Law. It's the general concept of, for those of you who remember those, the general concept of attorneys to a typical layperson, oh, they're always fighting in court and suing people, and you know, they're representing criminals, people who should be locked away, and why do they ever do that? And they cost a lot. Why attorneys? I can do this without attorneys. Well, yes, you can. You can start your business, operate your business, close your business, transfer assets. You can do all of this without an attorney. Let me give you the parallel. You can conceive, give birth to, and raise a child without a doctor. Would you do it? Probably not. It's not a good idea. It's always good to bring people into your business fold that you can count upon to advise you about, hey, I see this rash, or I've got this problem with my business. I mean, there's a lot of parallels here. I won't go too much further into it, but I think you get the idea. A concept of an entrepreneur is, I have an idea. How do I turn that into a business? Okay, that's conception. And then you've got to talk about prenatal care. How do I, while I'm thinking about formulating this, how do I make sure that once it's up and running, my business is healthy? Once I give birth to it. And so that's the first item here, before you begin. Why would you have an attorney? Why would you talk to an attorney? It's if you've got questions about the business organization, like we just talked about, how to do that, not only the ministerial aspects of it, but you know, the pros and cons of different forms, or whether or not you should go into business. That's all a business decision on your part, but maybe some legal aspects come into play here. Tax planning. There are attorneys who specifically deal with tax planning for businesses. Most often starting out, it's good to engage the services of a CPA and establish a relationship with a CPA that you trust, who can identify with what you're trying to accomplish and then help you achieve those goals. Intellectual property. The entrepreneur often says, I've got a great idea for a business and for a product. Well, there are two aspects there. The great idea for the product, that's easy. I get a patent on it, or has that being made before? Or am I ripping anybody else off? Or am I writing a book that is 95% copied from somebody else or from somebody else's speech? Yes, those types of things are protectable as intellectual property, and you want to be careful about using them in your own business if they truly are yours, and protect them so nobody else takes it and runs off with it. The other aspect is the business plan. You may have a unique thought about how you're going to conduct business, and actually a business plan is protectable under copyright law, the business plan itself. For example, the concept of online auctions for Pez dispensers. Yeah, eBay probably has intellectual property protection for that concept. And there are different variations that have come about since that was started, which are individually protected. But that particular business plan is likely protected under copyright laws, okay, as their intellectual property. I forget it's copyright or, actually I think it's patentable. See, I'm not an intellectual property attorney, but part of going through law school is recognizing the issue. It's not necessarily knowing how to solve it, but it's recognizing the issue. And now once you recognize the issue, you can put them in touch with people who know how to handle it. So I've got plenty of attorneys who, friends of mine who are intellectual property attorneys. Kind of a strangely fun bunch, kind of legal nerds, if you will, but they're still fun. Real estate and title. Let's say you want to open a business and you want a place to work. You've got a lease, or you want to buy a building and move into it with your employees. All that, that sort of planning. How do I do that? How do I protect myself? Where do I find the financing? Attorneys don't give financing. They may have some references as far as who can provide it. But if you run into issues, hey, I'm running into trouble as far as my credit or my ability to raise funds for this particular venture, there may be some information an attorney could provide or point you to other resources that can help you out and help you understand the lay of the land as far as financing. Construction, yeah, if you're building your own building, I've got a client who builds espresso stands, okay, and then sells them. And it's kind of a fun business, but sometimes you have to deal with construction as well. Securities. If you're offering an interest in your business to somebody in exchange for the receipt of money and infusion into the business, you're going to have to consider, does this invoke any laws regarding securities? Basically the selling of stock. Here's an investment for you. And the SEC, the Securities and Exchange Commission, those are the federal laws, and the Washington Blue Sky laws are Washington's versions of the security laws that you want to make sure you talk to a securities attorney about. If there is a private relationship, oftentimes those are not controlled by those laws. But if you're putting an ad, hey, I need people who are going to give me money for this venture, putting an ad out, and you're inviting people to invest in your particular venture, then you need to strongly consider talking to a securities attorney to learn the lay of the land and find out what you need to do to properly ask for that money.
Does the law, if you do that, and somebody gives you some money, right? And there's not a note attached to it where you're going to pay in back or a certain period of interest. But isn't it automatically considered by the SEC to be a security?
It depends on what was promised to the individual. Let's say you get a gift from your mom of, however many dollars, or, from another person. Yeah, I like this. Let me just give you some money and see what we can do with it. My understanding is that if there's no promise in return, like thanks for the gift, it really is not an investment, but it's a straight out gift. There are a lot of criteria for determining whether or not this is an investment, whether or not you're seeking investment, and putting out feelers for and inviting people to invest in your business. Once again, not being a securities attorney, even though that was my best course in law school. I just know that if you're looking at bringing in outside investors, you need to look at the securities laws and have an attorney talk to you about that.
What happens back in, maybe 6-7 years ago when PPM, private party memorandums, when a whole bunch of people, contractors especially, will try to pull money together to do a development. I mean, it's SEC won't. Do they really care if it's a PPM? Because, because you get exchange, you get stock.
Well, I think it's a private placement memorandum.
Yeah.
I think is what you're talking about.
Yeah.
In cases like that, there are criteria as to whether or not SEC and Washington get involved. And there are ways that have been developed so that it doesn't meet those criteria as something that would be regulated by the SEC or Washington.
So if we all came together and formed a company and we all put in money, like 10 grand for this percentage of stock in our own company, then that wouldn't be, and there wouldn't be an SEC concern. But if you were an outside investor and I was bringing in money and you weren't going to take a role in the company, then that would be.
Right.
You'd have to be a certified investor as well.
Yes, if I'm a member of a company, I'm in charge of my own company or have a couple partners, and we accept money from an outside organization or person and say, great, we'll give you a great return. As soon as we start making money, we'll pay you back. Or something where the person actually invests. Then you could be talking about securities laws. If it's a loan, the outside third party loans you $10,000 under a promissory note, and it's payable on certain conditions at a certain interest rate, whatever, that's a loan. And the expectation of the return is not speculative, it's required under the terms of the contract or the promissory note. Where you're asking people to speculate and offer their money toward that speculation, that's where you get into issues. Now, granted, going out on my own in my own business was speculative, as to myself, but I'm not inviting anybody to give me money and see how I do.
You're not asking them to speculate on what their return would be.
That's right. That's right.
5x or 10x.
And sometimes, well, I can't guarantee you're going to get anything.
Yeah.
Well, even those sorts of guarantees don't get you out of creating at least some sort of expectation that, well, I could get something. We'll see how it goes. Unless you told somebody, no, you're not getting anything back. I'll take your money, but you're not getting anything back. If you told them that, then it's not an investment. In fact, it'd be a really silly move. And before you begin business succession planning, what to do if you die or somebody in your business dies, who does this get turned over to? And we'll jump down a couple spots. When the business impacts you and your family law, let's say you and your spouse own the business and you decide you no longer want to be married. What happens to this business baby? Usually children are hard fought over, understandably. Businesses equally so, because now we're talking about money too. And people can become very emotional about money. So you'll probably be talking to an attorney about how to split up business assets during the course of your business, if that's your scenario. And it's even harder when you have a couple of people involved in the business. Two of them are married to each other, and the third party is like, okay, you guys are no longer going to be married. What do you do with this business? How do we redistribute assets? How do we change the management structure of the business to make it run as the parties may agree in their divorce proceedings? Never a fun time for anybody, especially when there's a business involved. And once again, it's when there are children involved. Okay, if you plan to have employees, you probably want to talk to an employment attorney about how do I get, keep, and fire employees. Sometimes you're going to be called upon to terminate an employee or two. How do I do that with the least amount of exposure to my business? What are the implications of terminating them? Do I have an employment contract with them? Like, have I obligated myself to keep them on hire for a year, or have they obligated themselves to stay on with me for a year? So contracts like that, usually you find them at the executive level. You don't often find them with the run-of-the-mill, if you will, the typical employee. But an employment lawyer will talk about employment handbooks, what to do, how to bring on new employees, how to treat them when they're working for you. You may also do with immigration and naturalization laws. You're going to make sure that each of your employees is authorized to work in the United States. And so when you get a new employee, you give them the IRS form W-4, which says, what's your social security number, sign here, how many deductions do you want? And you also give them an INS form I-9 that requires them to demonstrate who they are and that indeed they're authorized to work in the United States. And that's as to anybody, whether or not their family lineage goes back to the Revolutionary War in the United States or whether or not they just arrived in the country. So as you do business, if you've got a business transaction you're entering into, you want to enter into a contract with a vendor. Some people say, oh, just show me where to sign. You can get into trouble that way because amongst all these papers, there may be a provision or two that grabs you. Attorneys are oftentimes experienced in going through and zeroing in on these particular provisions that are not in favor of you as the contracting party, but they're in favor of your vendor, such as a default rate of interest going up to 26, 30% or something crazy upon failure to pay a loan when due. Government contracts, if you're doing government contracting, an attorney is good to go over those with you because those are even thicker than anything and they're in triplicate or more.
But is that a topic that you would look for a specialized attorney or someone who has experience in that field, or is that someone that,
The typical attorney is not going to be as well versed in the government contracting process as somebody who, for lack of a better word, specializes in that. As a profession, we're not allowed to say we specialize in any particular area. But somebody whose practice emphasis or has practice experience in that area. And so you try to connect with somebody and say, if you can't do it, make sure that you put me together with somebody who has had recent experience in this, because oftentimes the laws change and you want to make sure whoever you're dealing with is up to speed on the current status of the laws that affect the operation of the business, especially when it comes to government contracting.
okay, great, thank you.
Environmental law. I had a client who operated a hazardous waste recycling company down on the Tide Flats. And he sold the company. And the subsequent owner ran it into the ground, literally, spilling a lot of stuff and not cleaning up things, and was a part of the EPA Superfund cleanup site down there. And unfortunately, it was a nasty environmental issue. If you decide to take on property, buy a piece of property, you'll want to know if there are any environmental issues with it, because as the owner, whether or not you caused environmental waste to be discharged into the property, you now own it and you're now liable for what's there. There's a piece of property over on Heron Island. I don't know if any of you know where that is, little island in Case Inlet. One piece of property where there used to be a store, and the property is just very, very difficult to sell because there's an underground tank that used to contain gasoline. And it's going to cost a lot of money to remediate that issue, to pull up the tank, certify everything clean. And you have to know about those sorts of issues, first of all, with any property you're buying or any business interest you're acquiring. And second, if any of your business does involve the handling of those types of materials, because there are going to be a lot of regulations that come into play.
Can I add to that too, Mark? Because
Yes.
The purchasing of real estate, it's got to make sense for you as a business owner. But before you even purchase the real estate, what is called environmental report. So you hire, you basically pay for a firm to come in and figure out, okay, is there contamination? There's a phase 1 and phase 2 type of environmental report. Then that's a lot cheaper than going to see Mark, to help through this stuff, because environmental report would cost you about $1,500, just to see if there has been contamination. Then you can make a determination, okay, maybe this is not a good idea to purchase this thing before you execute the purchase sales agreement.
Right, and if you have those environmental reports ahead of time and have questions, then you can ask those questions of an attorney. Or actually of the person who did the report, if they've got other information that perhaps didn't make it into the report. And then you can also find out more information from the seller of the property to explain certain things, determine your risk, and then proceed from there.
So question, say the person you're buying the property from bought it not too long prior, and they did an environmental report. Is that something that, like a title report, that you need to do every single time? Or do those tend to be something you can sort of pass on? And then is the seller required by law to tell you all they know about those potential problems, or can they seek those by you?
Okay, I'll do the second one first.
Okay.
They are required to disclose any environmental issues with the property. And if they don't, as an affirmative misrepresentation, you can sue them. We'll get to lawsuits and litigation a little later on, but and you asked about, are those environmental reports good? Do they stay good? You don't know, because let's say the prior owner, the seller, bought the property 6 months ago and got environmental reports on it. Looked good. What did the seller do between those times? Did he operate a business changing people's oil and not doing any oil recycling? There are a lot of things that could change due to the acts of that owner that you don't want to take on. You want a brand new report, because that is going to be your personal assurance that what you're getting is the way the report states, rather than the way it was 6 months ago and things could have changed. Natural resources, oil and gas. If you're buying property, or if you're going to do anything like that, you got to know what's under your ground as well. See if anybody has any mineral rights or oil and gas lease rights. I've got a client who's got oil and gas rights, or owns property with oil and gas rights in Texas, and just entered into a large agreement for somebody to put windmills or wind generation stations throughout that property. Should have seen the documents. It was kind of fun. But there's a lot of interplay with how you're going to be using any real property that you might think about acquiring. But we're talking about starting a business, so I'll move on to that. International law and overseas trade. If you're going to be shipping something overseas, making a product, or doing business internationally, you'll want to talk to somebody about how to interact with customs, how to interact with shipping companies and carriers, to know about bills of lading and how to do business overseas. And you don't want to be doing that kind of learning as you go. Here's one issue that a lot of entrepreneurs have when customers don't pay you. Okay, I provided this product or this service and people don't pay me. Attorneys have the same thing. At least we know how to sue people, I guess. But you may want to talk to an attorney about, how do I collect that? Do I have to bring a lawsuit? Are there other things that I can do to kind of urge the customer to pay? And what can I do in the future to protect myself against such customers who don't pay? Getting money up front, getting deposits, things like that. There are a lot of other aspects an attorney can help you with. When the business impacts you and your family, the second issue there, wills, estates, and probate, estate planning, that really hooks into succession planning. Because sometimes in wills, I have seen all of my right, title, and interest in business XYZ. I want all my shares to go to this person. And if they're controlling shares, that person has to be, one, willing to accept the shares, because now they're in control of the company and may be required to run it. There are considerations that need to be taken into account here. If something goes wrong, the first item there, civil commercial litigation. ADR, which is alternative dispute resolution, very popular and is very necessary. Can we work this out without having to go to court and have them solve our problem? If you can't, then an attorney is the person to go to bring a lawsuit. Now, if you form a corporate entity, you cannot file the lawsuit on behalf of the corporate entity. A corporate entity has to be represented in court by an attorney. or somebody who's licensed to practice as an attorney, because it is its own entity. However,
So if you were dealing with another company and they're a corporation and you were, say, an LLC, then it behooves you to get a lawyer because you're gonna have to do something in court, because they have to.
yeah, if you're a limited liability company, if I sue somebody, if my firm sues somebody, it has to be represented by an attorney. Now, I can represent my company, but I would rather an outside attorney do that if necessary to protect my company interests, just because I may be called upon as a witness, and I can't represent the company if I'm going to be a witness.
Is that a law requirement a federal statute, or is it a state statute, or are there states where you don't have to be represented by
It's state.
a state?
And also the court rules of each state and the federal rules of civil procedure requirement. One thing I was talking about with this gentleman before we started, just the notion of lawsuits, talking about lawsuits right now. I just want to make sure I'm clear with you. You don't have to bring a lawsuit to do your business. I had a young couple come into me. They had just opened their business. They had a small issue with a contract, and they wanted to sue the person that violated the contract. They had just opened the business. And so they had gone to an attorney who charged them $1,500 and prepared a complaint for them, to file with the court. Okay, we can do this. And they said, okay, all right. And they came to me asking for a second opinion. I said, is that the way you want to start your business, by suing somebody? I don't think so. Your business ought to be your business. Think about the costs involved here, not just for the attorney, but also your time and energy, when it may be best put into actually exacting revenge on all those people that are trying to hurt you and being successful in your business. I mean, that's how you succeed. You need to weigh all this. And I said, you can file that if you want, but it's going to cost you time, money, and energy that is probably best spent growing your business. They were very surprised. They came to an attorney, and the attorney told them not to sue. Now, I didn't represent the other party, had no idea who the other party was. It just seemed to not make sense at that point. And I said, you can do what you like, but this, if I was offering advice, which I am, this is what I would propose. So be very careful and judicious in your use of the words, I'll sue you, or I'll see you in court, because you don't want to have to put your money where those, in your mouth, and et cetera. When you plan to close or sell, we are talking about business succession. The other parts about if something goes wrong, litigation, consumer claims, somebody's got a problem with your product. Criminal, one of your employees steals money and embezzles. Now you're dealing with criminal attorneys, now you're dealing with the state, and proving a lot of stuff against that. Or now you're dealing with employment law as well, because what do you do with this employee? Do you have to keep them on? Probably not.
Minimum as far as stealing, as far as from a dollar standpoint, for you to state and say, hey, we'll go.
Oh yeah, there are different levels of, first degree, second, third degree theft. There are different levels of criminal activity that are punishable.
Okay.
In insurance, I oftentimes have a client who's come to me and I'm being sued, or somebody's made this claim against me, and I'm all ready to jump in and defend them and fight on their behalf, and I think, wait a minute, maybe my client has insurance that would cover this claim, and that's a great benefit to have. And so just thinking about insurance, is there insurance to cover this? It's very important to be able to tell clients that, and to consider, do I have an insurance question? Is there coverage for this? Sometimes there are a lot of coverage questions. Well, no, that was an accident. It was not in the furtherance of the business, so it's not covered under your business policy. But when you plan to close or sell, once again, it's about business succession. What do you do with your assets? What are you moving on to? Are there any existing liabilities that will remain after you close your business that you've got to satisfy? A lot of winding up and wrapping up your businesses. It's not complex, but just thinking about all these types of things will be important to you. Now, the last thing I put on here is when would you use an attorney for your business, or when would you talk to an attorney? It's when you want to chat about other important issues. I just list some other areas of law. But two important ones have come up recently, and they're the last two. The next to last one is elections, if you want to chat about the elections. Oh, don't talk to me, please. But the last one, I'm always happy to field your questions about that, and it's to debate whether Army is ever going to win an Army-Navy game in football against Navy. So, and feel free to ask questions either after this or give me a call. My contact information is at the top of the page.
Before we end it, Mark, how do you pick an attorney? As far as
Do we look for?
It depends on the particular need.
Okay.
Let's say my business is being sued because somebody thinks that I was negligent in my work.
Mm-hmm.
First of all, I look at my insurance carrier saying, do you provide coverage for this claim? And they may appoint an attorney. If I want to learn about, let's say, I've got this great notion of a patentable thing. Where do I go with that? How would I go about finding that? Talk to the first attorney you come to. They're not going to know, but the question to ask is, who do I go to address this issue? Because attorneys become familiar with each other and their work. Reputations abound, but also just familiarity with who practices in what fields. You don't have to go thumbing through the digital yellow pages and hope you run across the right person. A lot of attorney work is done by referral and about people who are good to work with. If there was a commercial dispute, I would say, okay, how hard do you want to fight this? Or how aggressive an attorney do you want? Do you want somebody who's going to work to come up with an amicable agreement to fix this? Or do you want somebody who's going to take a scorched earth approach to this? And depending on the answer, I know who to refer that person to. Because I know scorched earth attorneys, and I know attorneys who are, yeah, let's work this out and have a reasonable resolution so we can all get on with our lives. Now, my goal in representing a client, and I would hope this is a goal of most other attorneys, is that if I'm defending or doing work on behalf of a client, I want to optimize the outcome for them. Either by charging as little as I can while getting them the maximum return. If you approach an attorney and say, yeah, I can get you your $20,000, it's going to take $40,000 worth of work, that's not going to be worth it. And so the overall cost, the net there is a lost 20. But if you go to an attorney, yeah, for $5,000 I can get you 10. Now you've got a positive 5 gain. Whatever you can do to optimize the outcome. Because you're not there, you are a client, you would be a client of an attorney. And they're required to look after your best interests, not of their business. Now, they need to protect their business interests. But they just can't say, great, I've got a wonderful pocketbook, I can run with this. It really has to be for your benefit. And just, never hesitate to ask questions about the bills you get, about charges you see, about the level of quality that you're receiving from an attorney. And if you're not satisfied, you can fire the attorney. It's not like, oh man, I've been with you this long. Well, it may not be worth it going on. Similarly, if an attorney feels that you're not being truthful or not being a good client, not paying your bills on time, or not participating the way you should, the attorney can usually fire you, unless you're like the day before trial, and then the attorney's kind of obligated. But select people you like and you're comfortable talking with, whether or not they are, from the Navy.
Go Air Force.
Or Air Force, yeah. Or Army.
Any more questions?
I have a question. If you have a corporate lawyer, you have your guy, and you have an issue where that's not his or her skill set, and they know another contact, is it normal that they would be the intermediary for you and you could pay them to cover the other lawyer, or would you have a relationship directly with that?
In normal cases, you have a relationship directly with that other attorney.
Okay.
If it's for that particular issue, that way, that attorney owes that attorney's duty to you.
Okay.
It's not a contractual relationship between that attorney and your corporate attorney.
Okay.
And I would feel badly about funneling funds through my business account that are due to this other attorney. Why am I paying him? He's not, I'm not his client. The real client is the client of his. So that's not to say you don't coordinate perhaps your work. If there's some crossover, and if I was referring to another attorney, I'd turn over all the information I've got, subject to the client's approval to do so, and say, this is what I know of the situation. Here's my preliminary thoughts on it. What are your thoughts, and can you take this further?
Okay.
So, but the attorney-client relationship is direct.
Okay. Thank you.
All right, thanks, Mark. I really appreciate your time.